Great. Good morning. Thanks for joining me this early morning in Killington. I'm Carl. I'm staff attorney at BLCT. I've been with BLCT for about 8 years now. Just kind of short on time, so I'm going to cut my intro short. There will be time for questions. I'll cue you on that later on. I'm happy to stick around if you want to talk about more questions that you have. And of course, you can always give us a call or go to our website for more information as well. So yeah, talking about the Board of Abatement. So who here is our listers, or all listers, or any assessors here? Assessor. So, but listers and assessors, of course, because just interesting to see the composition between listers and assessor. What municipality?
Springfield.
Hartford. Okay. And so probably by governance charter that I would guess is why you guys have assessors and federal listers.
We have both.
Oh, okay. So yeah, we're talking about abatement. Really what's going to be is going to be a general overview of the Board of Abatement and their role in terms of abatement hearings. I'm going to talk first just generally about kind of what abatement is and what it does and what it's not. And then I'm going to move on to talking about effective hearings. How do you hold effective hearings? And also how do you write an effective decision as a Board of Abatement? So abatement is, according to a Vermont Secretary of State's publication, they published an about abatement publication in 2014 that's pretty useful, and you can find that on the internet. I have a link on this presentation. They say that it's a statutory process for relieving taxpayers from the burden of property taxes, penalty, and interest when the law authorizes abatement if the board, in its discretion, agrees that the request is reasonable and proper. So it exists to permit the board to prevent an injustice or help a taxpayer who faces extraordinary circumstances that make it difficult for the taxpayer to meet their tax obligations. But it's important to know, as members of the Board of Abatement, for those listers and assessors here, and for those other members of the board that are joining us remotely, that when you abate taxes and interest and fees, it doesn't happen just in a vacuum. The result is that the town is going to have to either spend less or somehow raise that money in other revenue or through an additional tax. So therefore, you're in a way shouldering that burden on the other taxpayers in the town. So what abatement is not, in contrast, is a second chance for a taxpayer or property owner to argue that their valuation is wrong. It's a different process entirely. Okay, so you're all familiar with the tax assessment appeal process, right? You value people's property on the grand list, and people can read to you as listers or assessors, and then people can agree or can then appeal to the Board of Civil Authority and argue what their fair market value of the property should be there. And if they're still unsatisfied, they can go to Superior Court. That's the tax assessment appeal process, and that's focused on finding what the value of someone's property should be. Okay, Board of Abatement is not that. Okay, it's a different thing entirely. It's deciding whether the board is deciding in the Board of Abatement case whether they think it's just and proper to diminish or remove the burden of taxes from somebody. So if someone comes to you and the Board of Abatement says, well, my property's value is too high, or to argue about the value of their property, that's improper venue for that. So the Board of Abatement consists of the Board of Civil Authority, which is the Select Board, Town Clerk, and Justices of the Peace. And it also includes, in addition, the listers and the town treasurer. So all those top three things together equal the Board of Abatement. Interesting. So your governance charter, however, might modify this a little bit here and there. I know some towns that have governance charters have a little bit different of a structure and who composes the Board of Abatement. So just know that if you have a governance charter, that may be modified. And interestingly, for the default under state law is that for a city, the Board of Abatement consists of the mayor, city clerk, alderman, or city council, justices of the peace, and assessors in the city. And for the village, it's the village trustees, village clerk, justices of the peace, the listers. So missing, for some reason, state law has said that the treasurer is not on the board of abatement in villages and cities. Again, unless your governance charter says otherwise. So there is often a lot of confusion between Board of Civil Authority and Board of Abatement because they're really almost the same group of people. The Board of Abatement is just additionally the listers and the town treasurer. So what can be abated? So the law says that the board can abate taxes other than those arising out of corrected classification of homestead or non-homestead property, water charges, sewer charges, interest, or collection fees, or any combination of those in whole or in part. Okay, so it's pretty broad discretion. The state legislature added, as a side note, water and sewer charges, I want to say maybe like 4 years ago or 3 years ago, I can't remember. So that's relatively new. Note that if the board decides, well, the board, first of all, can decide to abate the statewide education portion of someone's property taxes. However, its town and municipality is still going to be responsible for the state for that amount. So that's just something to know. And collection fees and interest here mean for interest, town under state law can choose to have interest applied to late payments per month, interest per month. And so that's what that refers to. And for collection fees, that typically means the commission that the delinquent tax collector gets when the 8% commission they get when they're collecting late fees, late taxes, that is. Sometimes people call that a penalty or a fine, but it really just means the same thing. So an abatement can be granted only for if the requester falls under a certain category or meets a certain criteria. And on here, you can see the grounds for that grounds for when someone can get an abatement. Highlighting some of the relevant ones here that are probably more relevant because of the unfortunate events that happened in Vermont. Taxes or charges upon real estate or personal property lost or destroyed during the year, right? So towns might be getting a lot of requests for abatement because of the recent floods. And relative to that, towns might also get requests for taxes or charges of persons who are unable to pay their taxes, charges, or interest or collection fees. There's one in there that's sometimes misunderstood, taxes where there's a manifest error or a mistake of the listers. That's sometimes confused. Some people have confused that and think that the manifest error also has to be attributable to the listers or the assessor, and that's not the case. There's a Supreme Court case that has interpreted this to mean that the manifest error can exist independently from the listers. So it can be from another event or another person or entity that created the manifest error. And again, it's important to note that the Board of Abatement has discretion in whether it wants to abate. There's no requirement to abate. So it's a may and not a must under state law. So even if someone requests an abatement and they fall under one of these categories, or these grounds for abatement, it's not something that the Board of Abatement must do. And the other thing I want to note is that there's seemingly no limit to how far back the Board of Abatement can go in terms of, how many years back do they want to abate late taxes. So, as long as a person fits under the grounds for abatement and they have evidence to show it, then the board can decide to abate taxes from, a decade ago, for example.
Can the board impose its own limits within its town, or is that because there's nothing in law that states that there's a limit? Can they do that?
So the question is, can the board put its own limits on
How far back?
How far back? I think if the Board of Abatement came up with a reasonable policy and they were consistent, I think that would probably be okay. Generally speaking. For example, I'm pretty sure that Burlington, the city of Burlington, has a policy where they, after 3 years of, if taxes can't be collected after 3 years, then they have a policy where I think they go ahead and abate those taxes by themselves, because they're like, okay, it's been 3 years, our delinquent tax collector can't collect those. We're gonna kind of start the abatement ourselves and remove that from the books. And so I think generally the answer is yes to your question.
Okay. One other question, if I
Yeah.
may.
Yeah.
The taxes or charges upon mobile home removed from the town during the tax year as a result of change in use or closure of a mobile home park. What exactly does, so somebody sells an unlanded mobile home and it is removed out of town, does it have to be, because of the closure of a mobile home park, or what is change in use? I guess that's a question. If somebody partway through here.
Yeah, I don't think the courts have I've never seen a case that's addressed that one specifically. So I couldn't tell you actually the practicalities of that one. That's not one I've ever had a question about before. So I wouldn't be able to look at it, but I could afterwards look at it more and we can talk about that. Yeah. It's mostly unable to pay and damaged property,
Right,
and manifest error are the 99% of the ones that we get questions about. But yeah, I can look at that after. So a few things about what happens when the board decides to abate before we get into how to have an effective board abatement hearing. So if the board abates any taxes, then that automatically under state law abates any uncollected interest or fees related to that amount. If the town votes to collect interest on late taxes, then if you abate taxes, then the board also has to basically pay back that interest as well. And that will accrue from whenever the taxes were due or whenever person made the late payment. Okay, so it's kind of like, the point here is that if someone pays, let's say someone pays on time and then 6 months later they get an abatement and the town collects interest, even though that person didn't pay any interest because they paid on time, but they later got paid taxes abated, you have to also refund or credit that 6 months of interest, because the law is saying you're recognizing that opportunity costs of that 6 months of interest that person has lost out on. Note, however, that law does not apply. That requirement for giving refunding or crediting interest does not apply if the person is granted an abatement pursuant to property that's lost or damaged during the tax year. But the board can still also decide to do that nonetheless. So there might not be any delinquent tax collectors here present with us, but they may be joining us online. And we've gotten questions about what happens to the 8% commission or collection fee with the delinquent tax collector when taxes are abated. So we say that if the taxes have already been paid and therefore the delinquent tax collector has already gotten their 8% commission, then they get to keep that, and where the town and the town is still paying or refunding back that 8% collection fee. And so the DTC doesn't lose their 8% fee. And we think this because it's a agreement between the abatement, it's an agreement between the town, the board of abatement, and the taxpayer, and the delinquent tax collector is not involved in that process. If a tax is unpaid and it's late, and so if there wasn't an abatement, the DTC would normally be, if they got to collect it, we get that 8% commission. But if a tax is unpaid and the board of abatement abates, let's say, the collection fee, but not all the delinquent taxes, then unfortunately in that case, the DTC won't be able to get their commission. But then, if you think about it, what incentive does the DTC have then to seek collection of the late taxes if the board has abated their collection fee? And so it's just something to think about. And then I was saying refunding or credit as I went through this slide, but just to speak on that a little bit more. So when you abate taxes that have already been paid, you can either refund it or you can order that it as a credit moving forward, and then you can use up as more taxes, more tax bills are come out. Gonna move along here. Let's see. So effective hearings. So an effective hearing, when someone requests an abatement, you get to hold a hearing to decide whether to grant them abatement. And an effective hearing is one that follows all the state law requirements as well as your constitutional requirements, and one that also hopefully reduces the likelihood that someone will appeal to the Superior Court. State law, unfortunately, doesn't really give us a lot of detail in terms of kind of the process or procedure of how a Board of Abatement hearings should be run, but we do know that it's falls under the open meeting law because a hearing is a type of a meeting. If you think about it, because the Board of Abatement is a public body, a local board, and you have a quorum, a majority of that board meeting to discuss its business and to take action, whether or not to abate. Okay, so when the Board of Abatement, right, select board, listers, treasurer, clerk, justice of the peace are meeting to hear an abatement hearing, the open meeting law applies. And so therefore, you have to follow all the open meeting law requirements, notice, agenda, have the hearing be open to the public, and you have to have meeting minutes. So also when you are sitting and hearing an abatement request as a Board of Abatement, you should not come as any surprise that you're acting as a government, right? You're the government here, and so therefore you have a duty to protect the rights of those parties that are guaranteed by our United States Constitution. And so this includes the right to equal protection and due process under law. Equal protection, in short, really just means that you apply the abatement laws equally to similarly situated individuals. Okay? So another way to think about that means that you're focusing on the facts of the situation and not who the party is. Okay. Also, the Constitution, in terms of due process, what that means is that you're administrating justice, deciding on the abatement request, according to established rules and principles. And really, it comes down to treating the parties fairly. And by party, I mean the person who's making the abatement request. So, in broadly speaking, it's about giving someone notice of their abatement hearing, to giving them the right to come and make their case, and to be heard, and then making sure your trial is fair. And we're going to get into those in more detail here. So here are some kind of just broad steps. I just put 1 through 5, and we're going to go through these in kind. Seems like this is a lot for the Board of Abatement to deal with, but really, if you have rules of procedure for running your Board of Abatement hearing, then hopefully it'll be a lot more manageable. And I will get into rules of procedure. So I'm not really going to focus on this. Goes back to the open meeting law, and in state law, there's a specific statute that speaks to how the Board of Abatement meetings have to be noticed. And so this is kind of an administrative slide. So, you know, someone who is the clerk or who provides notice for your Board of Abatement really can just reach out to us if they have questions about this, but it's pretty obvious from the slide how you do this through the hearings. Again, agenda is required because Board of Abatement hearings fall under the open meeting law. You have to have an agenda that lists the matters to be considered by the Board of Abatement, which for hearings are going to be the actual abatement hearings for each property owner. And we have a model. If you go to bltt.org, if there's time, we'll show you on our website later. We have an abatement toolkit, the Board of Abatement toolkit, and in that toolkit we have a model, notice, and agenda. Really, we've combined the requirement for your notice and agenda in one document. So whoever is responsible for providing notice and agenda for your Board of Abatement can just use our model. And as long as you post it in the required places under state law, within the timeframes that you have to do, then you're golden in fact. Going along with due process and having orderly proceedings, you should be adopting as best practice rules of procedure that I mentioned before. So we have, again, we have a model for you, and I'll talk about our model in a minute. And the model rules of procedure are great because they provide a script for your chair and your board and the parties who are at the Board of Abatement hearing of how the hearing is going to go. Not having rules, we think, is kind of like people playing a game where there's no rep and no one really knows what's going on, okay? If you don't have rules, we think your Board of Abatement hearings are more apt to be longer and people will be confused and they'll be unwieldy. So we say you give out your rules of procedure to all those who are requesting an abatement before the hearing. You could do it when you send your notice to them. And when someone can look down at a piece of paper and say, okay, I know what's going on here. I know all the rules. I know the same rules that the Board of Abatement is following. They have the same document as I do. And so I feel like I'm being treated fairly. And so the goal here is efficiency, organization, adhering to due process, and also hopefully reducing the likelihood of appeal because people will think, okay, I know what's going on here. I don't feel like I've been treated arbitrarily. A couple things to note about your hearing. Some local practices are vary from town to town, but it's important to know that even though the chair is managing your hearings and following the rules of procedure, hopefully that you adopt or have, the chair is still has the right, like any other member of the Board of Abatement, to make a motion or comment or vote. Some towns or folks think that because they're the chair, they should be staying out of that. And in Vermont, state law does not require that. That's really just for town meeting. And when the moderator is moderating town meeting, that's where that applies. But for Board of Abatement hearings, the chair has a right, just like any other member, to participate in the hearing. And the other thing to note is that in hearings, the abatement person who made the request doesn't actually have to appear at the hearing. So they can just submit their request in writing to the board along with evidence that they have to show that, and say what grounds they have to meet an abatement and why they meet that abatement with evidence. And the board has to hold the hearing and decide, and they can decide based on what was submitted. So that's something to note. So talking more about a rules of procedure. So I'll try to move along briskly here because I do want to get to some critical slides, even though I know I'm short. So our rules of procedure here, starting in the top left corner at 1, going down to the bottom right corner to 8. These are the steps that we have in our model rules. This is not all information that's in our rules, but just highlight some of the steps that you take. So essentially, you open up the hearing, or the chair opens up the hearing and lists the taxpayer who's requesting and parcel ID and any other relevant information. Then you have those who are participating take an oath, and that's really going to be, the requester, any witnesses they may have, and or if they're being represented by an attorney or an agent. Then critically, you deal with ethical dilemmas, which are conflicts of interest, bias, and ex parte communication. And you do that before your hearing starts so that you can manage and debate and avoid those issues before you get into the core of your hearing. From that point, it's really turns to the requester to make their case to you. So they're gonna at this state what grounds they think they fall under for getting an abatement, those criteria we talked about earlier, and then present to you the evidence they have to show that they actually do fall in that criteria. You as the board can ask them questions. You also can ask for more evidence that you think is relevant. You can also take a recess if you'd like to discuss in private deliberations, whether or not you think you have all the information you need. You can also adjourn to a date and time certain to do a site visit of the property. For example, if someone is saying they got their property damaged or lost. So you have some flexibility with how you manage the evidence and how to proceed. Once the board is satisfied that it has all the information it needs, it then closes the hearing and tells the requester that it'll issue its decision in writing at a later date. And I'll get to deliberating in a moment here. So I talked about you'll be receiving information from the abatement requester, and really that just means evidence, right? They're proving to you that they fall under one of the grounds for abatement. And so what is evidence? Well, it's testimony documents, tangible and intangible objects that prove or disprove the existence of an alleged fact. Okay. The Vermont Supreme Court has called evidence substantial if it's relevant and a reasonable person might accept it as adequate to support a conclusion. Okay. In the Superior Court with the judge, the Vermont rules of evidence apply. And with your Board of Abatement hearings, you're not a judge. You're not in. It's not a real legal proceeding. You're not in court. You're in a quasi-judicial hearing. So it's quasi-court-like, but you're held to a lower standard because a lot of you are volunteers, and so the state law and courts recognize that. So you're not held to a higher, as high of a standard as the Vermont rules of evidence. So it's really your standard for allowing relevant and credible evidence is it the type that's commonly relied upon by a reasonable, prudent person? Okay, so is it something that you find credible? And so you're seeking relevant, right? So, and credible evidence. And what is relevant will depend on what the person's saying is their abatement request. So if, for example, property, they're claiming the property was damaged, what might be relevant there? It could be pictures of the property before and after. It could be insurance, home insurance information, right? So it just depends on what grounds they're stating that their abatement should be. And you want to make sure that you manage the evidence properly. This really, I would say, is to make it easier on your future self and your future board when you're actually making your decision, right? If you marked all the evidence properly, with the applicant's exhibit number and the name of the, you mark it, A1 marks abatement evidence, right? So then later on, when you're writing your decision, it's a lot easier to manage and have a thorough decision. And for oral evidence, you'll need some way to track that. And you can record your meeting if you'd like to, but you're required to. I talked about managing conflicts of interest or ethical dilemmas, and you need to make sure you avoid and debate and manage those. And every town has a conflict of interest policy. If you're not familiar with it, as a Board of Abatement member, you should familiarize yourself with that, and you can have your town's conflict of interest policy with you as well within your rules of procedure. If you don't manage conflicts of interest before the hearing starts, what can happen is that a Superior Court could void your board's decision. It can also remand it back for you to make a new decision without that ethical dilemma issue or that conflict present. Another negative consequence could be that it causes injury, public reputation injury to that town official, to the Board of Abatement, and in the worst case, to the town overall. That's something you definitely want to avoid. It can also violate the constitutional due process rights that we talked about of the interested parties. So we would say err on the side of caution and if it's questionable whether or not there's a conflict, for example, we would say err on the side of caution, and perhaps that town official would recuse themselves even if it's not 100% clear that they're completely out, because often the perception by the public can result in we're really, bad reputation hit against the town. So that's something to avoid.
I'm just gonna say, as a lister, we often are the go-to person for property owners when they're seeking abatement. And often discussing with, or at least in our town, seems to be the one discussing with and helping these property owners through getting prepared for abatement, calculating, helping them calculate what they're seeking, what they're asking for. So most of the time, unfortunately, we usually end up accusing ourselves because we are often there, have either assisted in presenting, getting evidence for the property owner or actually help them present the evidence for the board. That's probably the correct thing to do in those cases when we're sort of more directly involved in the process beforehand.
Yeah, so there's a question. The statement was that in their town, the listers often help a taxpayer prepare or give evidence to make their abatement requests, and therefore they often recuse themselves from board of abatement hearing. And I think generally that's the right thing to do, especially if you're doing that before the hearing or outside of the actual hearing. I would say that's a correct process. Yeah. So now I'm moving to the last part of the presentations about how do you have an effective decision, because you need to have a written decision about whether or not to grant the abatement. There's 3 broad steps I'm going to go through about kind of ending the hearing and how you're deliberating, and that kind of then in turn goes into voting and quorum requirements that we had a question about earlier. And then you have to do the last thing, which is writing the decision and issuing it to the interested parties. So to close your hearing, after you're satisfied all the information evidence that you need and has been gathered and your process is over, the chair can make a motion or entertain a motion to close the hearing. And so, say thank you, so-and-so taxpayer, we've got all we need, and we're going to close this hearing, and we're going to enter deliberations, and you'll get your decision issued in writing at a later time. So when you close a hearing under state law, you automatically enter deliberations as a public body, because again, this is a quasi-judicial proceeding. And now, before you were acting as kind of like a judge, right, quasi-judge at the hearing, and now when you're entering deliberations, you're acting like a quasi-jury. Okay, so this is when you're weighing and examining, discussing the reasons for or against the decision on whether to abate or not. But this is not the time where you are taking more evidence or hearing more arguments from the parties. Okay, that time is over. All that has to happen within the hearing. You're not allowed, and you shouldn't be going out and doing your own research and making the case for the person who's requesting the abatement. It's up to them within the hearing to provide you the evidence to make their case that they should get the abatement. We recommend you can have your deliberations as a board of abatement in public or in private, and we would recommend that you do it in private. This allows you to thoroughly and freely review and discuss the case for it without public or political pressure. Some towns say that just doesn't apply in their town, and that's okay. But our recommendation is to have private deliberations about how you're going to decide the abatement. And whether you deliberate in public or private, you don't have to, and we don't recommend that you announce your decision in public. So that's not a requirement, because under state law, you have to issue a board of abatement decision in writing. And so that satisfies the decision. And so there's no requirement to make a public statement about whether or not you're going to abate. And because there's a specific exemptions for deliberations under state law in regards to the open meeting law, the open meeting law does not apply. So when you're deliberating as a board, you don't have to notice it. You don't have to, post an agenda. You don't have to take minutes. The public is not allowed to attend, or they're not guarantee the right to attend deliberations.
Can I ask
Yeah.
a question on that? So there's been discussion in our town about voting in deliberations. Because you need to know what the group is thinking, right? You need a majority to make a decision. So is there or isn't there the ability to have a vote in those deliberations amongst the people, or what?
Yeah, so the decision stands for the board when it's written and sent out and issued, and so. Yeah, so just to repeat, for those online if you didn't hear, the question was, when you're deliberating, are you voting then in private deliberations too, if you deliberate in private? And practically, I mean, yes, you are, because you need to have a certain threshold, a majority of those that are present to make a decision. So if there's 7 of you that heard the abatement hearing, and I'm gonna get into this in a minute, there needs to be 4 of you in agreement. So when you're deliberating, as long as 4 of you agree on a way to go about the abatement, then in essence, you're voting in that way, you're taking action. And then, your decision will either be signed by the chair or vice chair or all those who voted, in favor of the abatement. So yeah, so in a way, I don't think you necessarily have to make a motion, but there has to be a majority of a quorum in agreement to make a decision on whether or not to abate, and that decision, that action would happen in deliberations.
But the only way you're gonna get that majority is to ask people to say yes or no.
Yeah, so you can.
So you're asking for a vote.
Sure. Yeah, it doesn't. All I'm trying to say, it doesn't have to be formal. Like,
Okay.
I make a motion to vote to grant it, but you can do that too. That's how your board would prefer it.
Okay.
So. In terms of voting in quorum and how many you need to show up at a hearing from the board and how many you need to be in agreement to make action, it's a little confusing. So start with the general state law that you might all be familiar with, is that for a public body to have a meeting or a hearing, it needs to have a quorum. And that means it's the majority of the total membership of the board. So in this example, my example, there's 5 members on this board. So a quorum would be 50% plus 1 member. So a quorum is 3 out of 5. Under the general state law, you also need a quorum, the same number, to take action. And so you would need, in this state law, general example, you need the same amount of people. If only 3 showed up, you need all 3 to be in agreement to take action. Okay. That's the general state law that applies to 95% of local boards. For the Board of Abatement, it's a little bit different. Okay, a little more confusing, but really not that confusing when we break it down. So state law here says that all you need is a majority of a quorum at a meeting, and that'll act that'll be treated as an act of the board. Okay. So in this example, we had 5 and you needed 3 for a quorum. And so in what I just said would still apply, but you only need, in terms of holding the hearing, you would need a quorum, which is majority of membership. So you need 3 to hold a quorum to hold the hearing. And then but then you only need a majority of those that are present. So you just need 2 in this example for the Board of Abatement. There's another little additional carve out for the Board of Abatement in that if you have in your town, if you have the treasurer, majority of the select board, and majority of listers, that also will constitute a quorum. Okay, so it's a little confusing. So that may apply if your town's having trouble finding people. So just to break it down. 1, you need a quorum first, hold your hearing, and a quorum is either 50% of the total membership plus 1 member, so the majority of the total membership, or the quorum can be the treasurer, majority of the listers, or majority of the select board. And then to vote, to take action, to decide the abatement, you need a majority of the quorum that is at the hearing. I could talk more about this later if you'd like. Okay, last, see, it's 9:08, this will be the last critical slide for those of you who need to scoot, who are present live. So writing your decision, you have to state in detail the reasons for your decision. You can't just say abatement denied or abatement granted. In terms of how much detail you need, the Vermont Supreme Court, again, recognizing that these are boards are comprised of a lot of volunteers. You're not required to make formal findings, but you need to have, let's see, you have to provide sufficient explanation to indicate to the parties and to the Superior Court what was decided and upon what considerations. Okay, you don't have to have a lengthy, exhaustive, legalistic, brief. Okay, it just has to explain your reasons for why you decided the way you did. And again, we have a model, like our model rules of procedure and model notice and agenda. We have a model decision form that you can go to on the website that are it's called our property tax abatement toolkit, and has a lot of great resources. In terms of when you have to make a decision, I know that I didn't ever say that earlier. State law actually doesn't say when you have to issue your written decision out and send it to the interested parties. But we would say, going based off what state law says for other local boards and the time they have to have their decisions, like the DRB, we would say aim for 30 to 45 days. All right.